Now read a second time. I call the member for Maitland.
Thank you, Mr Temporary Speaker, and I rise to speak to the Justice Legislation Amendment Bill number 2, particularly in relation to the Crimes, Domestic and Personal Violence Act of 2007 and the issues that arise there. The Labor is committed to the prevention of domestic violence, and we will work with the government in whatever capacity we have to do so to reduce this crime and to ensure that perpetrators are brought to account, but most importantly that victims and survivors are also looked after. I note that this goes towards the better streamlining of the apprehended domestic violence orders process, which was a resolution of the Coalition of Australian Governments, to improve particularly cross-border issues for those victims and survivors of domestic violence who need to cross borders. And actually for your electorate, Mr Temporary Speaker, that would be a big issue, and I've actually been down to Albury and met with someone where that has been an issue for them. This is something that we support. I note that the Victorian Government has now implemented their new legislation in support of these changes to get towards a better national process for victims of domestic violence. But what I do want to speak about in relation to this bill is that I think there's still scope for us to work on these, and while the Attorney-General's in the chamber, I think it's important to raise this with him. It's something that's been coming up a lot in my electorate and would be in other electorates around the state, and that is issues around emotional and or financial abuse and how ADVOs can properly deal with those, and then the enforceability of those issues. And it's something that's exercising the mind of quite a few people. And I note in Schedule 1.6, number CI, Schedule 1.6a, it talks about giving the courts the discretion if the defendant doesn't appear at the first return date or any subsequent mention of the proceedings to proceed to hear and determine the matter on the first or subsequent day on which the matter is listed for mention. So it's actually taking away some of that power that perpetrators have had to string out these cases by not appearing, by not being available, and that is something that we're seeing time and again in the family court, where perpetrators are using the delays in that system, which are due to lack of funding, to string out these cases. It becomes a case of the last person standing at the end of the day who's still got financial capacity to fight the case, who can still put up with the emotional abuse and stress and intimidation that's involved in those cases. And I understand the attorney doesn't have the capacity in terms of changing the Family Law Act, but I do understand that he has got colleagues on that side of politics who are at the federal level who could have that scope, and it is something that we need to turn our attention to. We did some groundbreaking things last year where we expanded the definition of domestic violence to acknowledge emotional and financial abuse, but we need to put the infrastructure in there in our legal system so that poor resourcing of courts doesn't lead to a systemic assistance to perpetrators to commit that abuse, because we know that where court cases are strung out, where they are lengthened and the times are long, that it very much in this space justice delayed is justice denied. So that is an important aspect there. The other thing that I'd like to turn the attorney's mind to is around how do you actually enforce orders around emotional financial abuse and domestic violence orders, because if I have and I have had a number of constituents come to my office who talk to me about financial abuse happening to them in their businesses, yet who do they report that to? The police are not seeing themselves in the role of placing an ADVO on a perpetrator of financial abuse, and if they did do that, how would they stop that financial abuse happening? I think it's beyond perhaps the ability of the police to undertake that. Where you might have, say, for example, I had someone in my electorate office who had a small business, their partner then liquidated the business, went bankrupt, allegedly gave all the assets of the business to their mates, got lots of jobs from their mates, continued on having a lovely time with lots of cash jobs. while the victim of that crime was left to raise the family, no access to the business that they had had an integral part in helping to set up and work through for many years. So these are quite complicated issues of abuse where we're seeing that the court system is perhaps not the best way, but I'd be interested to hear the attorney's views on that type of abuse. The other is around emotional abuse. You know, I've heard police officers, when I've spoken to them about particular cases where after an ADVO has been put in place and the perpetrator has been quite abusive on an emotional level, they are still having issues, and I'm still getting reports of people saying the police just told me to sort it out myself, perhaps write my book and get it all out off my chest there. You know, these are not appropriate responses to emotional abuse. They've also said we can't get involved in people's arguments. We're not actually understanding or acknowledging the deep power imbalances in domestic violence relationships, and that the women in those relationships, because it is often the women, are not, and mostly the women are not able to stand up and fight back, because, you know, on an emotional level, or stand up for themselves, because they have endured years of physical and emotional and other forms of abuse and violence. So it's a wicked problem, and it's not something that I expect the attorney will have an answer on, but I just would be interested to hear where the government is looking at that on that space within the confines of this bill when we're talking about changes to ADVOs. So thank you very much.